he has many credits, many publications, many achievements. I'd simply like to point to a forthcoming book of his that looks really terrific on the protection of fundamental rights in the internet, which I understand is perhaps may have already been published or soon, very soon will be. Our second speaker is Professor Kees Stuurman, who is a professor at Tilburg Law School, a law school very well known for its terrific work in the law and technology area. Professor Stuurman brings really a wealth of knowledge and practice in the broad area of information technology law. Our third speaker is Professor Dominik Boesl, who comes to us from the Bavarian University of Applied Sciences and Management. He again has really a fascinating background in the area of robotics, with a wealth of practical experience in that area. And our final speaker is Alan Winfield, who comes to us, who's Professor of Robotic Ethics from the University of West England. And he again really synthesizes both academic and practical experience. And I also notice that he is very much involved with the Institute of Electrical and Electronics Engineering, a really profoundly important body in the area of standard setting. So really that's enough from me. I've introduced all four of our speakers and they will go in the order that I've mentioned. I ask Professor Pollicino to kick off proceedings, and I also hope that all of our four speakers will self-regulate and stick to the 20-minute time slot so that we have lots of time for discussion. So without further ado, please, Professor Pollicino, the floor is yours.
Thank you very much, Professor Drahos. And I will say immediately something about what you kindly mentioned about my angle, that is the digital constitutionalism. But let me, first of all, thank very much Professor Bartolini, Francesca Episcopo, and all the great team of that is organizing this meeting. I mean, it's really an excellence in the tradition of Sant'Anna School. It's really a pleasure to be here. It's not rhetoric, but it's also the aim to cooperate also from Bocconi's side to this great achievement. So really congratulations. And now I think it's time for me to explain a little bit the angle of my presentation with the help of the slides that I suppose will be broadcasted soon. Thank you very much also, Francesca, for this. Basically, we can move to the second slide that immediately shows which is the angle. I will try to speculate about a kind of shift from the governance dilemma, that means state regulation versus self-regulation, to a little bit more complex layer of regulation. That means basically to try to answer to the following question. It's possible to regulate through fundamental rights enforcement, through constitutional law enforcement. And the provocative question would be, we really need legislation if we have constitutions, if we have regulation through adjudication, especially constitutional adjudication. I mean, clearly the question is provocative because the answer would be, as I will try to show, we still need legislation, we still need the good regulation through legislation because, as we will see, sometimes simply constitutional law does not apply to digital sector, especially to digital platforms that are basically the private powers in the conundrum of artificial intelligence. And sometimes the adjudication through judicial enforcement and regulation through judicial enforcement leads I will not say sometimes, but very often, to fragmentation and to basically affect the principle of legal certainty. Can we move to the next slide? And in particular, to the classic, let's say, genetic sin, original sin, if you want to call like this, but it's very easy exposed to evaluate as naive what John Perry Barlow was saying at the end of 90s. Basically, governments, you should leave us alone. This means a declaration of independence of cyberspace. Why I'm recalling this? Because I'm pretty convinced that the challenge of regulation for artificial intelligence are not completely new. On the one hand, they are new. On the one hand, they are based on the already existing models, on the already existing mistakes. And the challenge is what we can learn from the past, what we can learn from the mistake, or simply from the experience. And what we can learn is for sure that the self-regulation approach is naive. We can move to the other slide. Why? Because basically, it's very important not to focus, as Easterbrook was saying in a very famous Chicago conference at the end of the 90s. We could not focus only on the law of the horses, on basically one specific piece of regulation in order to face the new challenge of technology, but we should have the comprehensive pictures, the law of the animals and the Unitarian approach. The problem is sometimes it's difficult to choose between animals and horses. And if we go to the next slide, we know for sure that John Perry Barlow was naive, thinking that cyberspace would have been left in a way in the hands of the internet community, because we know, and this is, I think, a lesson that we can learn also with regard to artificial intelligence, we know that states can not only regulate, but they also can over-regulate digital sectors. And this is why we need a kind of digital constitutionalism approach. This means basically to go beyond what is in the hands of the single states in order to find a kind of European on global governance. And this was basically, in a way, emphasized by Johnson and Post. We can go to the next slide, and in particular to slide 7, because I think that Jack Goldsmith, when was basically saying that, look, internet is not different from others topics, other fields in which there was a transnational activity that needs to be regulated beyond national jurisdiction. So nothing new under the sun. I don't know, but if we move to the slide number 8, I think that we are slowly shifting from the lessons of the past to the challenge of the present, or at least of the last 10 years. And then we will see which are the challenges for the present and for the future. We know that even though European Union was very aware at the beginning of 2000, at the beginning of this millennium, that self-regulation was not the answer with regard to digital context, there was the decision, and I would say something about this migration of constitutional or regulation ideas from United States to Europe. There was the choice to basically believe in a kind of liberal digital approach. What does it mean? It means simply that the key word was minimum regulation, preserving freedom to conduct business, and basically through the e-commerce directive, foster innovation, foster e-commerce, and basically delegating private entities, not already private powers, but private entities, to basically have the role of gatekeepers in this new season. What does it mean? It means something very simple, that the idea was focusing on freedom to conduct business. And the idea was basically, the consequence was to focus on competition as privileged tool in respect to the alternative that would have been ex-ante regulations. This was something that, before being legal, was absolutely cultural. And it was a kind of migration of the liberal approach from the United States to European Union. But what I would like to say here is that if from a United States side, it was absolutely understandable to foster a liberal approach. You know very well that the spirit of United States constitutionalism is freedom, it's liberty. What was a little bit less understandable, it was this kind, let's say, of legal, a cultural transplant from United States to European Union, where there was already the idea of dignity, the idea to go beyond freedom, or at least the liberal idea of freedom. I mean, this was, I will not say a mistake, but it was a choice that in a way had few consequences. So we can move to slide number 9. Which kind of consequence? The first one was a kind of reaction from European Union side to basically the minimalist approach that I described. Which was the reaction? The reaction has basically 2 layers. The first one is the legislative reaction. It means basically to try to have more regulation and a much more activist approach in few fields, like copyright, like audiovisual media service, like prevention of terrorism. What does it mean? It means basically that through chirurgical approach, the idea was to circumvent without embracing and totally going over, but circumventing the original approach of e-commerce directive. And then there was clearly the judicial reaction. That means basically digital judicial lawmaking. It means basically the Court of Justice of European Union started to invent new roles like active provider, how much should be active in order to be responsible. I mean, this was an interesting exercise, but that had some consequence in terms of fragmentations, in terms of jeopardizations, in terms basically of affecting legal certainty. That should be really the cornerstone of a good regulation. We can go to the other slides. And in order to try to have also a transatlantic perspective, because another judicial reaction to this, let's say, first season was in a way very different in European Union and United States. Let's go to slides number, jumping a few slides, to slide number 14. Slide number 14 is basically one of the, I would say, most important keywords in the idea through which United States experience its approaching regulations. That means no regulations. That means basically trusting markets also in the digital fields. It means basically to take the intuition of Justice Holmes in 1919 and basically shifting from the words of atoms to the words of bits in order basically, for example, to deal with disinformation. Disinformation, in a way, should be fighted through the invisible hands of the market, through the competitions of ideas, whereas the false ideas are still competing in order to find the real truth. Now, this was again understandable approach from the United States side, a little bit less understandable if we want to export. There was the attempt to export in the European union side, because clearly there is the risk of a reject, and the risk is basically related to the different DNA. Again, from a constitutional point of view, liberty versus dignity. Now, if we move very quickly to slides number 20, then I think that we can see something that it's quite important. The next slide, please. That is basically the challenge that today we are facing. In the light of this experience that are not new, we know that something new it's emerging. And it was exactly a discussion of yesterday. Basically, the new algorithmic dimension, it's making a great change in this, let's say, narrative. Which kind of change? From freedom to conduct business to being a real private power. From freedom to conduct business, that it was basically the DNA of the liberal approach in the early 2000s, to being, for the platforms, especially in artificial intelligence, a real private powers competing with public powers. I mean, this was something that in a way Lessing was predicting in 1999, when he was speaking about the shifting from policy making to technician and informatics. Now there is another shift. That means basically from the human side to the automation algorithm side. I mean, these are really fields that needs a lot of exploration, but we can for sure look at the main challenge from constitutional law. That is basically changing geometry, changing perspective, not only a kind of vertical dimension, authority versus liberty, but I would say horizontal dimension, in which the question is, can we apply constitutional law and especially constitutional rights towards private powers? And then we can finally go to slide number 23, that in a way it's showing again the existing I would say conflicts between the two sides of the Atlantic. On the one hand, there is what I would call thank you very much, what I would call the digital liberalism, that in a way makes impossible to apply in the United States the Bill of Rights and especially First Amendments to private powers, to digital platforms. So the question is, can we, this is the original question that I raised at the beginning, can we basically avoid legislation by enforcing fundamental rights, constitutional rights from an horizontal perspective? The answer is no, United States, because we have what we call state action doctrine. Basically, states should do a step back and not interfering in private disputes. This is why we still have a kind, I would say, of bipolar approach in the United States. On the one hand, the Supreme Court is considering that First Amendment, the other rights, should not apply to platforms, to private powers. On the other hand, for example, in Buckingham, also in other cases, it's considering social network as a public forum. So from a subjective point of view, nothing is changing, but from a space point of view, there is something that is changing. Basically, this digital space is not considered anymore just a neutral space, but a public forum in which there is a special importance for the exercise of freedom of speech. What about the European approach? The European approach, it's in a way similar and different from the United States one. It's totally different because we know that there is the horizontal application of fundamental rights. So in order to answer to my first question, is possible to count on a regulation through enforcement of fundamental rights in a horizontal dimension? The answer is yes, and we know this already from the past. We know already from Google Spain, we know from Schrems, we know from Digital Rights Ireland, and this is something that will happen more and more with regard to artificial intelligence regulation. Basically, European Court of Justice will not wait for the legislation, but it will, in a way, will apply directly, horizontally, fundamental rights in order basically to enforce those rights vis-a-vis private parties, vis-a-vis private powers. On the other end, there is something in common. What is in common? What is in common, I think this is a very important, I think, for the future of regulation of artificial intelligence. What is in common is the new kind of approach that is clearly enshrined in the Digital Service Act. It's basically a kind of procedural approach that is not based on substantial values like it was until now. It's not based on the European constitutional law with regard to the substance, but it's basically based on the due data process, on the right to ask for the access, for the translation of algorithms, the rights basically of explicability, everything that is related to the procedural relationship between the user and the platform. And this is something that is already in the DNA of the United States approach, because the Fourth Amendment, the Fifth Amendment, the due data process is something that is not totally unfamiliar to the experience of United States regulation. And this is why I think this is the Unitarian humus, or at least it's a bridge between the two sides of Atlantic, much more than still focusing on the substantial values that will remain different in regulation, because, as I said at the beginning, the spirit of the United States Constitution is based on freedom and liberty, will never be the same of the European one that is based on dignity. Now we can go to the next slides, and again the next one, please. And I have just 2 minutes, I see. And these 2 minutes I will use in order to describe which is the approach of the European Agency for Fundamental Rights, where I have the privilege to sit at the moment. The approach is basically related to a report that has been adopted last year in December. And what I think is very important, it's the focus on two principles of the Charter of Fundamental Rights that, according to European Agency, should be applied, should be enforced directly horizontally. Is Article 21, principle of no discrimination and equality. That this means basically fostering discrimination through algorithms. And the second one is the Article 7 and 8, the especially data protection. This is really my last point. Data protection today in the artificial intelligence season need to be in a way, I would say, translated in a different context. Basically, what the European Agency is saying is that the European Union matrix based on personal data is not anymore fit for the artificial intelligence matrix, especially for big data. Why? You can guess why. The big data matrix, it's absolutely disconnected by personal data, because platforms are basically doing a kind of profiling exercise without the need of having the personal data of the user, but through ideal typos. This means basically the GDPR, the added value of the GDPR becomes also its great weakness, because simply doesn't find applications with regard anonymized data. And then which lesson again can be learned from United States? something very interesting. Article 4th Amendment of the United States Constitution, it's in a way more fit to big data. Why? Because it's not dealing with privacy, it's not dealing at all with personal data, it's dealing simply with physical trespass. But, there is a but, the Supreme Court, in its interpretation of this provision, is able to find a new matrix, that mosaic theory, according to which the single bit is not in contrast with the Constitution, but the aggregation of the bits without being personal data are a problem for the United States Constitution. This means, again, I would say, an attempt not only to teach from the European Union model, but also to learn. This is, I think, this reciprocal way of learning and teaching can really build a bridge that is going to be stable. Thank you very much.
Okay, thank you, Professor Pollicino, for that talk, and lots of interesting ideas actually for us to think about. So without further ado, I'd like to invite Professor Stuurman to give us his talk. Thank you.
Thank you, Peter. Let me try to share the screen. There we go. If it's okay, then you should be able to see my slides. Ladies and gentlemen, good morning, welcome. Thank you, Andrea and Francesca, for having me on this interesting conference. And from the title, ladies and gentlemen, you can learn that I try to sneak in two topics actually in my presentation. First, I want to talk to you about my approach to regulation in the field of AI. And then highlight in a few slides at the end also the potential interesting and important role, in my view, of technical standards when we look at regulating artificial intelligence. Now, this is a brief overview of what I'm about to share with you. Obviously, we all would have liked to see this impressive historic monument in real life. And to compensate a little bit, I included this picture. But obviously with a clear purpose, because it is a metaphor about the way I look at the current situation when we look at the regulatory framework, on top of which we are about to add rules and regulations for the field of AI. But when adding things on top of something which might also already have some issues, then we should obviously be very careful. And what are the issues that I would like to share with you? And it is basically the broader concept of access to justice. For decades already, I've been very concerned about the access of justice for individuals, private persons, consumers, as well as small and medium-sized enterprises. And we can see that due to cost for legal procedure, cost for legal expertise, and also bureaucracy and formalities, access to justice for real non-digital issues like labor law, rental law, etc., is under pressure in many EU countries already. And digitization will actually put further pressure on that in the relationship with the government and consumers, and the citizens will be confronted with automated decision-making. And the digitization in the role as consumer will also be burdensome, because digitization will actually include or imply that they will be confronted with much more cross-border transactions. There will be much more expensive and scarce expertise needed to actually fulfill a burden of proof if you want to file a claim. And digitization also results in a loss of control. And if we compare, for instance, in the field of IoT, so Internet of Things, then we can see that the digitization of functions of products actually effectively weakens the protection of the owner under property law. And the shift of power to those who can exercise contractual rights or IP rights with regards to the products of service they are taking out. But this is really a big concern. And in practice, it shows already, at least in the Netherlands, and it's probably valid in a broader perspective, that we see that access to justice is more and more a privilege of action groups, claim associations of other deep pockets. And my deep concern is that AI will actually further push that development. And it's not only the focus I want to put on citizens, on consumers. What is often overlooked, I would say, and undervalued is the position of SMEs, small and medium-sized enterprises. Data from 2018 suggests that SMEs constitute 99.8% of all enterprises in the European Union in the non-financial sector. And 93% of them were even micro SMEs, so less than 10 persons. And obviously, as we are all aware in the platform discussions, we can also see that people are moving from employees to be independent contractor, further strengthening this problem. Also, SMEs don't have the cost, the time, and the power, I would say, to really take on the government or take on competitors. Then can citizens and small companies turn to supervisory authorities in the digital arena? Unfortunately, the answer is not very positive. If we look at the field of data protection, obviously most of you will be aware of the ongoing discussion about the lack of staff, budget, and expertise in the data protection authority organizations. Similar concerns are shared with regard to consumer rights. So the key question I'd like to put forward, and I look forward to your comments as well, is can we actually afford to build an AI framework without strengthening the underlying pillars for the protection of consumers and SMEs? Now, then I'd like to move on to making a few remarks about what I called AI regulation in context. First of all, it has been mentioned before, AI is not a delineated and precise concept. If we all participants would make a description, then I'm pretty sure that we would get as many different descriptions and delineations. So actually, it's a bundle of technologies with different characteristics, different risk profiles, different actors involved. Actually, AI is a moving dot on a line with a yet unknown direction. It's also a relative young technology, it's immature, and many developments are to be expected. So this is actually only the beginning of a journey, and that obviously also should be taken well into account when we talk about regulating this new phenomenon. Now, another observation that I'd like to share with you, this is a serious concern I had already for a number of years, that if we look at the high-level expert group principles, and that are currently the basis for the European approach, then we can see that a lot of these principles, actually almost all of them, are not uniquely for AI. They are equally relevant to what we could call modern ICT. And what is modern ICT? Modern ICT is data-driven ICT, it's networked ICT, so connected, and it is cloud-based. And all these IT solutions and services that most of us in both professional and consumer capacity are working with on a daily basis, they all share these concerns. Human agency and oversight might be less prominent due to autonomy in this modern ICT. But issues like privacy, data governance, accountability, etc., are fully on target. So we have to be cautious in focusing on AI too much. And any regulatory response to AI should, in my view, cover all relevant technologies. And that actually also answers a little bit the question hidden in the title of my agreement. I think actually that if we focus on AI, that will not be the right standard for dealing with the current technological development. We have to take a broader approach. And I'm frankly happy that issues like transparency and accountability with regard to modern ICT have become on the table right now due to AI. It should have actually, we should have had that debate already many years ago. A third aspect, if we look at AI regulation in context, is a few remarks about the current debate. I value, and I think it's very important that we have, especially in the academic debate, but also in the policy level, we have a strong human rights focus. And I think that is valuable, but on the other hand, it might have also a risk. If we talk about AI only in human rights terms, then AI becomes in the debate pre-labeled as high risk. And that might actually have a chilling effect with, on the one hand, the end users, individuals, but also small companies might be scared off by introducing this technology. And obviously, by making this remark, I do not imply that I would be for a less critical approach to those aspects of AI. But I think it's important that we are more precise, and we also put the spotlights on other applications of AI, like especially in industry, that are far less sensitive from a human rights perspective, but also call for our attention. So one of the concerns I also have in the debate that it is very one-sided. I think that it is extremely important that we take as a starting point that the AI regulation is building on top of. And I showed you the Tower of Pisa, and maybe I'm more confident about the underlying concepts, but there are concerns, as I shared with you. AI, it doesn't start from scratch. So what I see in the debate and what I miss in the debate also is the role of gap analysis. Obviously, there are a few good examples, like the report of the group of liability experts from 2019 in December, that is a part of the AI white paper. And there are other examples as well. But in the academic debate, I miss a focus on key issues like consumer protection, safety, market access, etc. And these are all valid and useful bodies of law that are fully applicable also. For instance, take the medical products regulation. If you have a robot in a medical setting, then primarily it is a medical product. So we have a whole set of regulations that are already applicable. A final concern on this slide is that sometimes the debate focuses a lot on over-the-horizon issues. AI is a moving dot, and I explained in an unknown direction. We expect a lot, but we really don't know what will happen in 5 to 10 years. So I was also very happy with the remarks made by Ursula von der Leyen in her inaugural speech, that the Commission would focus really on, say, the first 5 years and would not focus too much on over-the-horizon issues. And I really want to underline that, because I think it's practical. It's important that we focus on realistic problems. And obviously for the academic debates, the outlook could be 10 or 20 years from now. But if we are close to the policy debate, then it's important to keep in mind this realism. Now, then the next question actually then comes on the table. What are actually the starting points for AI regulation? As we learned yesterday, we are within a short period of new steps on the European level. But so far, the latest document is still the Inception impact assessment that was launched in July last year. And there are a few important elements there, what I want to highlight and share with you. It was important that the Commission was put in writing that the potential harms we see in AI are not per se new or otherwise necessarily tied to AI only. And that also reflects to the remark I made before about the relevance of modern ICT. But also very important that in the debate, we often see remarks jumping forward to new regulations. That's a default response in a part of our community. If we see a new technology, we immediately think we should have new regulation. But it's also important to take a closer look. And then the Commission concluded, and I fully share that it's actually a twofold question. On the one hand, we have enforcement issues in the field of human rights, and we might have scope issues in the field of especially safety legislation, where we might have extend. But again, the message is not on default new regulation all over. And so we should be cautious there and take both strands actually into consideration. Now, how should we actually proceed? Obviously, it's just a few remarks because a lot has been said and will be said about it. And any 20-minute presentation would not be sufficient. Again, let me reiterate that in my view, AI does not emerge in a regulatory vacuum. So I see a key role for gap analysis, and that will also imply that in many cases, we much more need a sectoral approach than a higher level horizontal approach. That was also already a debate yesterday during the panel. We should not throw everything overboard, but start with what we have and try to expand it. In technology terms, then my phrase would also be that we rather need something like a new version than an entirely new design. We don't have to start from scratch, but we have to carefully expand what we have, and then we can already cover a lot of ground. If we look forward, and it's yet unknown what the Commission will come up with, but if we look at recent initiatives that are very relevant in the field of AI, then I must say that I have concerns about what is awaiting us. If we look recently at the Cybersecurity Act, the GDPR, and the product safety legislation that we already know from the 1980s, then we can see that the Commission has actually took a path that can be considered as an inconsistent and unharmonized approach. If you look, for instance, at the legal status of self-regulatory approaches, elements in the Cybersecurity Act, the GDPR, and under the CE marking legislation, then we can see very different approaches. Under the new approach, we can see a presumption of conformity if a product meets certain technical standards. Under GDPR, if a controller or a processor obtains a certificate, it is not clear what is the legal value of that document. Also, there are diverging methodologies for accreditation, for assessment, and that actually puts a very significant burden on especially European economic partners. And again, here the position specifically of the SMEs. And what always strikes me, if I read through the European policy documents, then it seems to be that somewhere in the Brussels typewriter, there is under the heading considerations, there is a minimum of 20 references to SME and their special position. But then when you move on to Article 1 and the following, you don't see anything there. And that also applies, for instance, for the GDPR, which gives rise to very significant enforcement issues because it does not provide clarity. It does not provide a clear legal standard that can be met by small companies especially. So I don't want to reduce any way the concerns we all share about the position of individuals. But that position of citizens is also actually benefiting from a rapid and solid implementation. And that requires also that we pay more attention to enforcement issues and implementation issues. And ultimately, again, taking the characteristic of the European economic landscape into account, in which the SMEs are by far the largest operators, we should not forget that unclear legislation and overload of enforcement costs and burdens actually favors large corporates that are often not based in union. So I think it's very important that we come to clear standards and metrics, assessment methodologies and oversight structures that are really critical. We cannot only stop by designing high-level horizontal principles that will be really to the detriment also of the European economy and ultimately the protection of citizens and consumers. Okay, and then finally, I still have a few minutes to go. A few words about technical standards. Now, technical standards is a topic that I cherish already for decades because I think it's a fascinating topic. And I also see actually that it would play a very significant role in the field of regulating AI. We need to come to clear legal standards and all those other assessment metrics, etc. And to give you a practical example of the importance thereof, during one of the previous meetings of this conference, I was in a panel with a colleague who was also involved in the design and production of robots. And a practical point he made that there was in Europe at that moment in time a lack of laboratory for the testing, conformity testing of robots. So making only high-level regulation without taking into account assessment metrics, methodologies, and facilities is clearly putting a brake on things. Now, technical standards, and previous speaker already made some remarks about self-regulation, and it's no doubt a topic that will reappear in other panels as well. Let me first of all say that I'm not blind for the weaknesses of self-regulation. I think that there are a lot of concerns about self-regulations, but there are also a lot of concerns about hard regulation, as I briefly set out. And then why would I promote technical standards? I think, again, we need these specific norms and metrics and assessment methods to really ensure that economic operators start using AI in a responsible way. and that compliance is raised to an acceptable level shortly. Now, if you look at the dynamics of the state of the art in AI, then it's definitely very flexible. And this is, again, this dot moving on a line with an unknown direction. And industry is heralding very significant progress in the next few years, full autonomy, etc. And a lot of exciting things are going to happen. I'm confident not everything will make it, but we see a lot of things going. So how do we actually, and we have been confronted with this challenge before, we need flexibility. If you look back at the e-commerce directive and following up of a huge set of regulations and directives, then we have seen that codes of conduct, etc., in the initial days of e-commerce played a very significant role. And I think, again, we are now in a moment of time, if you look at technological development and meeting regulatory challenges, that we need this interaction with industry and academia. We cannot expect that governments have the knowledge and the skills we need to come up with those precise guidance in the form of legislation. So we need to structure this interaction with technical experts. And then I think that standardization can be a platform facilitating this approach. Now, standardization is something that is long-standing. And it has even in part been recognized already in the European Union. In the regulation 1025/2012, often referred to as the standardization regulation, there's actually something like you call pre-clearance for the regulatory use of technical standards. It is a specific types of standards because it is developed by those standard development organizations that are actually recognized by public authorities in Europe. And on the European level, we are talking mainly here about three European standards bodies, so CEN, CENELEC, and ETSI. Under certain conditions, the results of their work can actually be used. And I think that really builds a very interesting platform. And referring back also to yesterday's panel in which Ben Wagner made this important remark about the need to turn to the values and expertise of professional associations, I think to some extent the established track record and reputation of standardization body can fit in that frame. If you turn to formal standardization, then there is there's a governance structure, there is clarity as regards access, there is some form of oversight. All parties concerned mechanisms will assure that everybody's voice can be heard, etc. That doesn't mean that there are no concerns out there. And I summarized a few concerns, and you'll appreciate it's actually a huge topic, but so I just want to make a few dots. First of all, what is a concern is that the integration of the recognized STO standards in the framework still raises some questions. And those of you who are familiar with the European Court case law in the James Elliott case, where the court would say that harmonized European standards are a part of European law. Now, that was quite astonishing, but we're still struggling with the meaning thereof. Another and more also serious issue is that this standardization regulation is actually focusing on incorporating the results of recognized standardization organizations in the European regulatory framework, thereby overlooking, neglecting to some extent the fact that in the field of standard setting, we have over the last decade seen a strong competition by industry, fora, and consortia that are not recognized as STOs. So only under very exceptional circumstances can the results of that global work be taken on board in the European regulatory approach. And actually, I think that is a pity. And obviously, there's a policy struggle behind. And the Commission opened the door a little bit, but would like to open it much more if I'm adequately informed. But it actually means that we are so far on focusing on European standards, but there are much more valuable standards out there. And actually, if Europe wants to really fulfill its promises in the field of AI, then we should look to the best standard and not be hindered by this limitation in the standardization regulation. And then finally, it is very important to realize that standardization is no longer a national and even no longer a regional activity. Standardization has actually moved to the global level. And obviously, the US and China are very strong competitors there. And that actually means that the European values in standardization will not have to be defended in Brussels at the tables of Saint-Sénélec or in the south of France at the tables of ETS, but they should be defended at the tables of ISO in Geneva and elsewhere around the world, but also taking developments on board with regard to what industry, fora, and consortia has brought. So in sum, I think that standards are a very powerful tool, and they can be a mediation, provide a platform for this mediation between policymakers and the latest state-of-the-art knowledge in academia and industry. And I really think, and I hope that the Commission is relying on this instrument, because we have a strong track record on that in Europe already. It comes with some concerns, but nevertheless is very promising and powerful. So this actually summarizes what I tried to communicate to you. I think we are working on AI regulation, but there are structural underlying problems, access to judgment, enforcement issues. And also still what we see is there in the regulatory framework, there is a division between the regulation of tangible products and digital products. Some repair has taken place, but we still have fundamental issues out there, like for instance, the scope of the product liability legislation that is still focusing on material products and doesn't take into account digital products yet. That is something that would have to be repaired shortly. In sum, we have also, on top of that, we see GDPR, Cybersecurity Act as examples. It's a partially fragmented and incoherent regulatory basis. It is what we need to be working for, but we have to be cautious in not continuing on that line. Extremely important that we refrain from focusing on AI as a core. It's not AI, it's modern ICT, in which autonomy is maybe the new kid on the block, but a lot of the other issues apply on a much broader range, and we should focus and try to stay away from AI-only regulation. Thank you, and I look forward to the debate and your comments to my presentation.
Okay, thank you, Professor Stuurman, for that very broad-ranging picture, and particularly the insights into the role of standardization. So, Professor Boesl, I hand over to you.
Perfect, thank you very much. So, first of all, thank you very much to Andrea and the organizers for having me. And actually, the great thing is, thank you, Professor Stuurman, for your presentation, because I couldn't agree more. And although I meanwhile switched to industry, I switched from industry to academia, I still gonna take a little bit the hat of industry, and especially of these SMEs that you have been talking about. And so actually, I wanted to say something, or in my presentation, give an insight that is a little bit similar, or would have been a little bit similar to what you just did. And first of all, well, yeah, hard regulation doesn't solve everything. We have to be careful because technology is moving so fast, and it's not just the horizontal regulation. We really have to also look at that we come up with something that really helps industry and that can be applied by these small and medium enterprises. So what I'm now going to do is I'm going to shift a little bit the focus of my presentation, and I try to give examples because I do come from this field of robotics that you also had been tapping into. So let me just see if this works here, because I'm gonna switch to the next slide. Hope that works. Yes, it does. So actually, I want to speak about why I do believe that we need robotic and AI governance frameworks, and that they do not have to be hard regulation frameworks. I much more believe in self-regulation and into something that is directly applicable, which doesn't mean, by the way, that we couldn't lift it up to the level of hard regulation as soon as we find that it has worked out and made sense. But still, you know, what I want to emphasize is that we really need these pragmatic approaches. So don't worry, I'm gonna come back here, just small and little down here on the right bottom side of the screen, and I'm gonna be talking to you from there. So also to the organizers, don't wonder, you only have one camera stream for me and the slides will be integrated. So so far, what has been my job so far? Well, I actually come from IT industry. I started with Siemens in '99. Then I have been with Microsoft for several years. Then I worked for KUKA and have been responsible for technology and innovation management. And then that later on 2 years at Festo for building up their robotics department before now did the switch into academia. And my job has always been to predict the future. And the problem with predicting the future is that, alas, it doesn't work. All of you might be aware of this. Unfortunately, my CEOs usually and CTOs were not. They were always asking me, what should we develop? When should it come? How much money should we spend? And all that. And this was a bit of a challenge because, well, as I said, in the end, we don't know how it's going to evolve. The only thing that always saved me was that, well, basically it never really has been possible. So I bring just 2 or 3 funny examples. In the beginning, in 1830, people believed humans die when they ride on a train, which was quite funny because the reason was they believed that our bodies were not made for the high speed above 30 kilometers an hour. By the way, even then, people were talking about regulation and we're talking about, do we have to forbid this? Do we have to limit the speed? Do we have to sell safety equipment, so like pressure suits and stuff like that? Luckily, nothing of that has been necessary, but well, yeah, it was a broad discussion. Things like this were highly discussed. So Never Will a Rocket Leave the Planet was a title of New York Times in 1936. Today, they are landing again, and we're at the edge of private space travel. So Elon Musk and Bronson and Jeff Bezos, what they're currently doing with that. There is also the question, this is a very, very disruptive technology, but how are we going to regulate this as soon as this is going to happen? And I totally agree. Space travel is, and air travel is is very much regulated. But if you're coming up with disruptive ideas and new business models, then sometimes you're clashing into that. And that is the same thing that applies to all these disruptive technologies. Then, well, yeah, IT technology, there also have been large misconceptions. So Bill Gates in 1981, which is now, funnily, 30 years ago, he said, nobody will ever need more than 640, and now careful, kilobyte of main memory. And this is particularly funny because today, in the age of AI and big data, we're speaking not about kilobyte and not mega and terabyte, but peta, zeta, yottabyte. And well, he predicted that nobody will ever need a lot more than 640K, which is, well, makes us smile today. But it shows how fast it can evolve. And why do I bring this up? Not just because it's funny, but also because one of the fundamental issues with those technologies is that disruptive innovation cannot be planned. And even worse, because you cannot plan it and only recognize it usually in retrospect. So looking back, you can say, yeah, the car and the transistor and everything, that was something big, but you cannot really say it before. And this makes it so hard in order to regulate the ecosystem around it. And what we have to be very careful about, and this is why I highly appreciate everything that has been said before, and particularly by you, Professor Stuurman, we have absolute difficulties in limiting innovation through too harsh regulation. And so we have to avoid this. On the other hand, we have to address the concerns that definitely are out there. And I'm trying to raise this even a notch because now I'm in my presentation, I'm not just talking about AI, but I'm talking about, well, in the earlier days, it used to be called robotics. Now, if I look at the European Union documents and also the Commission documents and everything, mostly people speak of the embodiment of AI. So robotics has turned into a container for smartness. I'm going to get to that in a second, and you see that I might not fully agree to that, or that I do believe that there is more to it than that. But anyways, what I think we can say is, or what we have to look at is actually megatrends. We have to look at how the world is going to evolve and what is going to happen around us. And well, this is now broadly accepted. Megatrend research has become the thing that people are looking to. Also, if I if I look at what the United Nations are currently doing with the SDGs, so the Sustainable Development Goals, they do a lot of megatrend research. They come up with scenarios. They say, listen, if we want to feed the world, then we have to do X, Y, Z. If we want to avoid climate change, then we have to do this and that and that. And so these scenario techniques are absolutely great. The notion was actually invented by John Nesbitt, whom you see here above me. Let me just reach over to my bookshelf here, and I didn't prepare it just for this presentation, but I really always have it at my desk. I absolutely love and adore his book. Written in 1982, he was defining a megatrend as two things. First of all, it has to be global. Secondly, it has to affect the whole humanity. And the great thing about 1982 is now in 2017, we're far beyond 25 years of prediction time. So we know that he was right. He actually was right. He was predicting the information age before the internet really happened and some other things. So looking into megatrends and trying to understand how the world is going to evolve is going to help us exactly with that. And by predicting these developments, we could also start already thinking about which areas might need regulation. Careful. I don't say we have to immediately start regulating them, though, especially not with hard regulation, because if we do that, and sorry, Germany, but look at Germany, what happened there a long time, or has been happening there for a long time in autonomous driving. You were not really able to do autonomous driving on German roads, although many of the foundational concepts around autonomous driving have been laid in the 90s here in Germany. In the 90s in Germany, we had the first truck driving completely through Germany on the Autobahn. Later on, this was no longer allowed. So we had a really hard time to test these concepts here. So their regulation, and especially hard regulation, can inhibit innovation. Not that you couldn't find spaces where you can do it. You can go to test tracks, you can go to other countries. So a lot of the stuff has been tested in the US, especially in Nevada and so on. But still, you know, it doesn't really help your industry if you have to go to the other end of the world because you cannot test what you're developing in your front yard. And so I heavily vouch for that we should be trying to avoid this, especially with AI, but also with robotics. So some of the important trends, oh, and sorry, there are only two captions that are hidden behind me, and this one says urbanization. So one of the trends that are really leading to fundamental changes in robotics is urbanization and gentrification, because the whole supply chain and the whole intralogistics and interlogistics supply chain will change. Reason is very simple. The United Nations predict that in 2035, 53% of the global population will be living in cities and metropolitan areas. Amazon currently is offering you a pilot program in San Francisco and in the area of 45-minute delivery. If you want to have things delivered in 45 minutes, it's clear that A, you can no longer have your dispatch center somewhere on the outskirts of the city, because you know that even I think in Pisa or in any other big city, Vienna or London, New York, Munich, wherever you go, you don't get anywhere in 45 minutes in rush hour. So basically you have to know what people want before they order it. That's where the AI part comes in. You need the data to do so. So you need to know which quarters will need more iPhones and which ones do need more baby diapers, for example. But it will also mean that maybe you will have to manufacture and individualize stuff while it's still in transit. So why not assembling the last bit of your product, especially when it's about individualization, printing on it, lasering on it, engraving things? Why not do this in the delivery truck? And you can also see this on a large scale, and we just had a very good example of this. As soon as the Suez Canal is blocked, we run into a huge global problem. So because those things that are on these ships, they are on international waters for 8 to 12 weeks. If your market changes or your demand changes, or you find out that people no longer want a black phone, but they want a pink phone, how do you react? Well, in those 12 weeks, not at all. The fastest you can react is immediately, but then it will hit your market 12 weeks after that. So the question is, why do you not do final assembly and all these things on the container ship, in the container? By the way, which might also be an interesting notch, because Well, if you do it the right way, all your added value is generated on international waters, and you might not have to pay taxes on that. So, as for industry, this might be highly interesting. Although personally, I'm not a huge fan of tax evasion. So there, you really have to differentiate. So please don't say that this guy from Munich said that we should be trying to avoid taxes. No, not at all. Actually, I think it's a very great move, and there we're also getting in the direction of regulation. That now there is the demand for a minimum tax for companies everywhere in the world. So we're getting to this global governance frameworks, but it's also interesting that now a lot of big companies are asking for that. So sure. Yeah, and I'm going to get to that in the end of my talk. They're going to get to this because of external pressure, but still they are asking for it. So yeah, this is one of the important drivers. Well, basically, you can sum it up and say we're living currently in a world where you can sit at the Mount Everest base camp and you can order a pizza through the internet in San Francisco. The only problem you're still having is delivery, but there are also companies that are trying to work on that. You know, if this is feasible, if this is sustainable, that's nothing that I want to discuss here. But at least it's from a technological point of view, it's possible, and we have to see if people want this, if the market wants this, and how we want to react to that. I totally agree, though, that if everybody is now ordering pizza at Mount Everest through drone services, then, well, it might look like a beehive, and it might also bring some additional dangers to it. So then we really have to see that we react accordingly. But I also totally agree, a lot of the current regulation can already be applied to these things. We only have to double check. So if there are new challenges coming up. So the other important driver is individualization. I no longer want a smartphone. I want my smartphone. It has to be different from yours, but it shouldn't cost anymore. And well, this is also a huge challenge for the flexible manufacturing of the future. There are completely new manufacturing concepts evolving that, for example, involve humans and robots working together. And there I have a very good example where regulation actually was not really our friend, because if you know about the German machine directive at a certain point said that a machine is never allowed to touch a human, or a manufacturing machine is never allowed to touch or interact with a human. Now imagine you're a robotics company that are building robots for human-robot interaction. See the problem? You build a robot that is intentionally made to interact and to cooperate with a human, but you have a part of regulation that says a machine is not allowed in the manufacturing process to actively touch and interfere with a human. The reason is clear, because when this regulation was written some 30, 40 years ago, it was big and massive and fast and dangerous robots that lived in cages. So basically a robot zoo. But as technology was progressing and as new ways of manufacturing have been developed, the problem was that this was actually limiting a whole segment of products. Luckily, I think 2 years ago in April or so, this machine directive has been updated, also thanks to the research of some international institutes, especially also Fraunhofer and all of these institutes that have been working on the measuring of forces that can be applied to different body parts and so on. But there you see, existing hard regulation has been inhibiting innovation to a certain extent, and then we needed a very fast way to interact with that and to reshape it. So in that case, that was one of the best examples that I know in the last years where innovation and regulation have directly been interfering. So yeah, then demographic change is also leading or pushing manufacturing, because, and I have been showing this slide for many years, and now actually it's already 1 year ago, that since last year, more than 50% of the German population is older than 50 years. So that means we're overaging, we're running out of human labor, and in the end, we will have to automate, because people are no longer cheap muscle. People are bearer of information, of experience, of creativity, and exactly of those things that AI cannot do, but they will be directly interacting with technology. And in order to sum this up, we can say we're living in the Anthropocene, in the human-made age. And so what I have been building to, and Andrea, I know you're about to get a heart attack about time, but no, I have an eye on time. What I'm also getting to, and this is why it's so great that you, Mr. Stuurman, have been bringing up standardization. I'm fully in favor of what you have been saying, because I don't know, yeah, it should be showing up here. This says, what is a robot? And that is still a fundamental question, because we read a lot about robots, like robot process automation, robots in software and hardware, and so on. There is no exact definition of a robot, not even a standard. There are some standard suggestions. There are some first preliminary drafts from ISO, now also from IEEE and from other standardization bodies, but we don't really know what a robot is. The reason also is it's not so easy to say what a robot is and what's not, because, well, for me, as I'm a roboticist, a robot definitely needs a physical representation. But there are some other people out there that say, no, virtual assistants, AI, can actually be a robot of some sort because they have autonomy. And this will still be an important debate. And I think that is actually exactly where standardization comes in. And this standardization is dearly needed in order to then build regulation on top of it. So what I'm also currently doing, this is one of my projects. Sorry, some advertisement has to be done. We're currently setting up a global Delphi study where we ask 200 internationally renowned experts. I just got a chat comment and I'm going to respond to it in a second, but thank you. We're setting up a Delphi study where we're asking 200 internationally renowned experts about what they think how robotics is going to look in 15, 30, and 50 years. 100 of them who are building robots and 100 of them who are going to be affected by robots. So like industry and also the philosophers and, well, clearly a lot of people that are also in today's panel. So Alan, you just have been writing ISO 8373 is very precise about a robot. Yes, I'm definitely aware of that. The only thing is that I already know a lot of people that are very unhappy about this definition, which I totally agree is a different story. So this is now where there are going to be some other counter standards. And I know that there are other standards in development that are extending ISO 8373 or even contradicting it a bit or limiting a bit and so on. But yeah, you're right. They do exist. So this is what I meant with the drafts. Sorry, I have not been very clear about this. I just know that the robotics community currently is not really happy because always some people feel left behind. And I just feel that there is going to be a lot of further discussion in this field. When we talk about robots, then a lot of people have actually these things in mind. So they are afraid of those robots that are walking autonomously. And this is also why embodiment of AI and a lot of people have the Terminator in mind. I can actually tell you that this is far from the truth because those robots are by far not as autonomous as you might think. And by the way, if you're afraid of the apocalypse, the robot can run 15 minutes on those batteries. You only have to do 16 and you're going to be safe. So this is the good news. The other news is that they're going to have many different forms. And now we're getting into interesting effects. For example, when you see this robot to be mistreated, then a lot of people have the immediate reaction that they go like, oh, the poor robot, because it looks like a dog, actually. Interestingly enough, we have to think about the human wish for anthropomorphism, or that we always try to put the soul into things and the effects of that. So for example, if you know the movie of Her or Ex Machina and all that, there's always the question, are we going to identify with those systems? And or do I have a right, for example, to know that I'm interacting with a robot or with a smart assistant? And I personally think this is very, very important, that if I call a call center and at a certain point, artificial intelligence might be as good, that I cannot differentiate first level support from a real person. I would love to be told that this is a machine that I'm talking to and actually not a real person. With the robot dog, it might not be as problematic, and also not with these creepy things, but it's getting more and more important as we're looking at robots that might have different forms. For example, like this here, what Hiroshi Ishiguro has been building. So Hiroshi is on this side. The robot is on the other side over there. or when we get into the field of prosthetics, so many of you might know Hugh Herr, who currently is doing a lot of really awesome research in the field of prosthetics. But his vision actually is not to give people back capabilities that they might have lost through an accident. He says the next step of human evolution is going to be bionics. And he wants healthy people to cut off their legs and arms and to replace them with what you're seeing back here. And so I think immediately in that moment, many of you might agree that this should be maybe even not allowed, or at least to some extent regulated, because otherwise we're going to get in the problem. Well, even if you say if people want to do that, why shouldn't they do it? If you're very liberal. On the other hand, you're getting into the point that you say, what if people that cannot afford this cannot compete with people that have body enhancement and body augmentation? So as you see, there are a lot of interesting questions coming up, and not just the trolley problem, but also, well, how are people allowed to interact with robots? What are the challenges connected to that? There are studies showing that first people are manipulating robots and sabotaging robots because they're afraid of them, because the robot never has Monday, because the robot never takes a break. The question is, how do we have to protect certain groups of our society from exposure to robots and artificial intelligence, especially children and elderly people, or people with certain incapabilities that are maybe even not possible to differentiate that there is a robot. So for example, there are studies that are showing that 5-year-old up to the age of 5, kids cannot differentiate between a character on the TV, a real person, or a robot if they're telling them something. They take it for the same. They think, oh yeah, that's just a personality that is telling me something, which might be okay if you're using it in a teaching context. But the question is, how about advertisements? How about influencing people and so on? So this is definitely a field there where we have to look into it. And then, yeah, also exposure of elderly to robots. And then in the end, the question of body augmentation. So here you have Harbinson, who has been implanting a camera into his head. Should things like this be allowed? Well, currently, also by the Hippocratic oath, it's not allowed, because this would be a surgery that is not healing. It would be body altering. It's the same problem that, or challenge or issue that the body modding community is facing. So we will have to look into the question: is this possible? Should this be allowed? Should this be possible? And you see, we're fluently crossing over from areas in industrial manufacturing where maybe some existing regulation might be inhibiting innovation, to other areas where a lot of people instinctively might say, oh, we have to regulate this. This shouldn't be allowed. This shouldn't be possible. The question is just not so straightforward as you might have seen. So to wrap this up, and this is one of my last slides. I don't believe what Bill Gates once said, that there will be a robot in every home by 2025. This will just be 4 years, but maybe it will be there in 2040. But what I do believe is that the generation of our grandchildren will grow up in daily contact with these technologies, and they will be the first generation of robotic natives. But ladies and gentlemen, this leaves us with a very interesting role, because we are going to be the last generation of robotic immigrants, still with very analog migration background, but we will live through this change. And especially in this change, this will be, for many of us, this will be the second big wave of disruption. First was the digitalization, and the second is going to be the automation of the world. And to just wrap this up, and to quickly jump into techno-dualism, one of the challenges that we're facing with all technologies is that there's always dual use, or the possibility of dual use. They can be used for great things, but they can also be used for bad things. And same thing applies to artificial intelligence, to robotics, as applied to nuclear technology. And I'm just saying we should be very aware of what we're doing, because we're meddling with very disruptive technologies. I'm not saying dangerous technologies, I'm saying disruptive technologies, and I don't want us to end up like Oppenheimer here, who, when he saw the effects of the atomic bomb, said, now I'm become death, the destroyer of worlds. I also don't want to use good old Goethe here. Die Geister, die ich rief, werde ich nun nicht mehr los. The spirits that I've stoked, my commands ignore. So we're meddling with disruptive technologies, and I'm just saying we have to talk about their impact. Stoking fear is not the right way, I believe. I more believe in something that I like to call robotic and AI governance. I do believe we need governance frameworks for this. Very close to maybe the things that have developed around green IT or child labor. And I know they have their limitations. And I know at a certain point, soft regulation has to be transformed into some sort of hard regulation. But I would love to see this way of changing our thinking, and so that industry becomes aware of this, that the general public becomes aware of this. We have an obligation to explain technology in an understandable way. We have to involve all the stakeholders, and especially general public, interest groups, and also the small and medium enterprises. I hope we can reach at least a minimum consensus. There, I would still love to see a robot. Sorry, now I have to move. Really have to move. A robot manifesto, so a robotic charter, and I also do know that there are drafts of that. I just haven't seen one that has been broadly accepted, and now I just threw over my screen here in the back, but it doesn't matter because I'm more or less over. Sorry. Yeah, and with that, I just want to leave you, and sorry, Andrea, for going 2 minutes over time. But yeah, this is my take on this. And actually, I just wanted to advertise or emphasize what you have been saying. Yes, I don't think that hard regulation is the only way. It will be a way, and we have to find a good way to transform soft regulation, which should be developing before hard regulation into hard regulation. And we have to see the needs of industry and especially small and medium enterprises so that they're not fully overwhelmed by these regulatory frameworks. So let me just switch back to the first slide because we have this nice official background. And yeah, with that, I would close my session. And yeah, thanks for your attention. And I'm very much looking forward to the discussion.
Okay, thank you, Professor Boesl, for a really fascinating insight into what commerce throws up, not least of which in terms of moral dilemmas. And also for the idea of floating tax havens. I think a desperate cruise ship industry will be fascinated by that idea.
Yeah, definitely they will.
Yes. I can't think of a better person to end this panel than a professor of robot ethics. So, Professor Winfield, the floor is yours.
Thank you very much indeed, Peter. Thank you. Let me just share my screen. And can I just check that you can all see the presentation okay? Thank you, great. So yes, I was certainly cheering along to a fair bit of what both Kees and Dominik said. I mean, I'm a big standards evangelist. I'm working a lot in standards. I think they're really important. I also think that regulation and ethical governance are important. But let me instead talk about AI accident investigation. So in this short talk, I want to really make the case for why we should be investigating AI accidents. So the talk, it's only short, but just 3 parts. First, the first part is why we need AI accident investigation, and then how do we investigate AI accidents, and finally, who would investigate AI accidents. So really the why, the how, and the who of AI accident investigation. So, of course, accidents happen, and this is just as true of AI-based systems as any other artifacts. But how often, what kind of accidents are they? And here, we're fortunate that there is an AI incident database, which is absolutely fascinating. I recommend that you take a look at this if you have an opportunity. It's only been set up relatively recently, but already lists well over 1,000 incident reports. And I strongly suspect that those 1,000 incident reports are really the tip of the iceberg of AI accidents or incidents. But the scope of those in this database is breathtaking. So it includes everything from, for instance, driverless car fatalities through stock market auto trader crashes to wrongful arrest because of misidentification of facial recognition software. So the breadth of and the kinds of accidents or incidents reported here really is extraordinary. And in a sense, that is, a major part of my case for why we need accident investigation. So really, it's clear that AI accidents cover a much broader range of harms than conventional industrial accidents or road traffic accidents. And an important point I want to make here is that the AI accidents cause ethical harms in addition to physical harms. Of course, physical harms are in there too, but the ethical harms include psychological harms, societal harms, and of course, environmental harms. So this little Venn diagram illustrates that actually the scope of AI accidents is much, much broader than of traditional physical harms or safety risks. And I'm speaking to you as an old-fashioned safety engineer. I spent the first 10 years of my professional career building safety critical systems in industry. And so what do I mean by psychological, societal, and environmental harms? Well, psychological harms, again, they're a very broad range, and these are some of which are defined in British Standard BS 8611, which I'll refer to again in a minute. They include things like addiction to an AI, deception by an AI, over-trusting in an AI. Now, none of those might be regarded as particularly serious harms, but they might, on the other hand. Societal harms, well, these clearly include things like loss of employment because of AI. They include things like very poorly paid employment, the kind of gig economy, the ghost workers that sit behind many AI systems that we use every day. These are societal problems. And of course, the really big one, the elephant in the room, if you like, of societal harms, is the very harms to democracy that we believe are attributable to AI-based targeted political advertising. And then, of course, environmental harms are really important. We know that AI is a huge consumer of energy. And there are all kinds of other reasons that we should be concerned about the environmental harms of AI. Now, are those accidents? I don't know, maybe, but certainly there is no doubting that the scope of harms due to AI is very, very broad indeed. And because AI is pervasive and ubiquitous, then the potential for ethical harm is considerable. And that's why I believe that the 1,000 or so accidents listed on the AI incidents database is really just the tip of the iceberg. So, and here I'm referring directly to BS 8611, which does define ethical harms, hazards, and risks. An ethical harm is that which compromises psychological and/or societal and environmental well-being. And a hazard, of course, is just a possible source of ethical harm. I like definitions, and I was part of the drafting of BS 8611, so that's why I wanted to introduce those. But the final really part of this first section, the case for why we need accident investigation, really I need to tell you that the primary purpose of accident investigation in general is learning. And so I'm not talking about AI accident investigation, I'm talking about all accident investigation. Typically, accident investigators are concerned with three questions. What actually happened? Why did those things happen? And what does that reveal about weaknesses in the system that failed? And then the third question is, how can the system be improved to prevent similar events happening in the future? And the ultimate aim of any accident investigation is to come up with targeted recommendations for making safety improvements. And again, if we're talking about AI accidents, they would be ethical safety improvements. And here I'm going to just add a quote, which is really the motto of the very long established and very well regarded aviation accident investigation, and that is that anybody's accident is everybody's accident. In fact, it's worth noting that in aviation accident investigation, there is a long-standing tradition of data sharing across manufacturers of aeroplanes. Now, that is probably going to be very difficult to achieve in AI, but nevertheless, it's worth reflecting on the fact that this culture of data sharing, and also and behind that is an understanding that accident investigations in aviation are not designed to attribute blame. In fact, interestingly, the evidence of aviation accident investigations is not admissible in a court of law. And there's a lot of evidence that shows that these features of aviation accident investigation have really led to the extraordinary safety of air travel, of aviation. So I think there's a lot to be learned from good practice in existing accident investigation. So let me turn now to the second part of my talk. How would we investigate AI accidents? Well, essentially, accident investigation needs four things: technologies and process frameworks, which I'm going to introduce very briefly now, and then the third and fourth I'll cover in the final segment of this talk, which is investigation teams, people to investigate the accidents, and also statutory instruments that might determine when those accidents are investigated and by whom and by which authority. And again, I'll reflect on those right at the end. In fact, I'm part of a project in the UK, a UK-funded project, EPSRC-funded project called Robotics. And in Robotics, we are really focusing on the first two of those four things I just mentioned: the technologies for accident investigation and the processes. So we're developing frameworks and policy recommendations for how to investigate accidents with robots and AIs. And I think probably what is a first in the world of any project that we know of is that we are in this a 5-year project. We're conducting a series of 3 staged accident scenarios. Now, these are all with robots, but they could be with disembodied AIs. So we're constructing scenarios with assisted living robots, with educational toy robots, and driverless cars. And of course, they'll be staged. Nobody will be actually harmed. and we'll have actors playing the part, volunteer actors, of course, playing the part as of subjects of the accident, the people to whom the accident happens, but we will also be seeking human volunteers to be witnesses to the accident and members of the accident investigation team. We should have, in fact, run the first of these scenarios in the past 12 months, but of course the pandemic and the lockdown has delayed that, but we hopefully will be running the first one within the next 6 months. Now, the technology that we believe is essential as a fundamental requirement of accident investigation is what we call the ethical black box. The idea is very simple. It is simply that we should equip all robots and all AIs with the equivalent of a flight data recorder as currently equipped in fitted to all aircraft and some, but certainly not all, cars and road vehicles. Very simple idea. It's just an event data recorder. It's a device that logs events, and that would typically include inputs, sensory inputs and actuator outputs for a robot, and importantly, the decisions for the reasons for the decisions that were made by the robot as it's operating. So my collaborator, long-term collaborator, Marina Jarocka, and I wrote this paper in 2017 called The Case for an Ethical Black Box. Why are we calling it an ethical black box? Well, fundamentally because it would be unethical. It would be irresponsible not to have one. So we're developing this technology right now. We're building model ethical black boxes, and the idea is that all of the source code for both physical devices and software modules that could be fitted to a robot or an AI will be open source. We're also, in fact, writing an open standard for the ethical black box. That should be published in a couple of months, I guess now. So I'm now going to turn to the process framework. Now, I don't have time this morning to go through this in detail, but I'll just refer you to a paper that is currently in press called Robot Accident Investigation, a Case Study in Responsible Robotics. And in that paper, we set out an imaginary scenario, an accident scenario, which involves an assisted living robot. Again, I won't go through this in detail, but the paper is, in fact, on Archive. There's a link at the end of the talk, or I could post the links in the chat window if you're interested. That develops exactly how we would propose to investigate the accident. And fundamental, of course, is the data from the ethical black box, the EBB. So this rather complicated diagram shows a visualization in time, and this is -5 hours, 4, 3, 2, 1 hours before the accident, which is where Rose, the subject of the accident, falls and is discovered by a neighbor unconscious on the floor. And what's not clear at first is whether the robot caused the accident or maybe exacerbated the accident. And this timeline is essentially the ground truth. These are the facts that are provided by the ethical black box. So the ethical black box records things that it did, waiting for instructions, reminding Rose to drink water and so on, and its movements, which are the blue boxes underneath, and other events like robot losing connection with the home hub and such like. Again, this is explained in some detail in the paper. And also in the paper, we recommend for accident investigation, and this is, we're not unique in recommending this, but certainly I think we're the first to set out a framework for robot or AI accident investigation. We recommend the technique of why because analysis. And the idea is that this why because analysis allows us to create a graph that constructs, as it were, the likely causes of the accident. So the graph is interesting because it shows two accidents. So Rose's fall, which is accident 1, accident 2 is robot failing to raise the alarm, which is of course equally important. And each of these boxes leading up to those set out the causal reasons for the accidents. And in fact, the boxes have different meanings. So square boxes are a change of state in the world, they're events. These boxes, there are processes. Those processes are actions or sequence of events pertinent to the accident. States are things that remain true for the whole of the accident, things like there are robot sensor errors, there's no data from the home hub. And there are unevents. And unevents are interesting because they are events that should have happened but did not, like the robot fall detection system not being triggered when it should have been. So again, I'm sorry this is a very brief overview, but I just wanted to share with you the bare bones of a framework, if you like, a process for accident investigation. And I would suggest to you that this would apply equally well to AI accidents as to robot accidents as in this example. So let me now turn to the final segment of the talk. Who would investigate AI accidents? Well, it's well known in the existing AI accident community. I don't mean AI, I mean accident community. There isn't an AI accident community, which I think there needs to be. What's well known is that accident investigation teams are multidisciplinary. So typically, an investigation team would need an expert in accident investigation, and they would typically be the leader of the team. You would also need to have, of course, high-level AI expertise and experience. So this is the sort of wise, experienced generalist in AI. You'd certainly need to have expert knowledge of the AI-based system that is at fault, and that may well be from someone, as it were, from the manufacturer, from the operator who joins the team to assist with the investigation. And you'd almost certainly also need application domain expertise. So if it's an accident with a healthcare AI or an automotive, autopilot, you'd need domain expertise that would also bring to bear. And this is just a minimum set of areas of expertise that would be needed for that team. And it's very interesting that in the UK has, I believe, the world's first accident investigation bureau for healthcare accidents. And it's very interesting that the lead accident investigator in that organization, in that bureau, is in fact an experienced aviation accident investigator. So the important thing here is that accident investigation expertise doesn't have to be domain specific. It's really expertise in how to investigate accidents. And then really my final slide is actually a set of questions, because here I'm well beyond my kind of expertise, my comfort zone. And this is where I'll be very interested to discuss and hear feedback from colleagues. So it's a question. The question is, what statutory instruments do we need for AI accident investigation. That is, of course, assuming that we accept that such investigation is needed. So what kind of regulation would be needed? And that also begs kind of subsidiary questions like, how do we define a threshold of seriousness, of severity, that would then automatically trigger an accident investigation for in particular domains? How serious does an accident need to be for it to be investigated formally? Of course, less serious accidents, near misses, are also important. They're important not only to be recorded, but also, of course, to be investigated, but perhaps not with the level of depth of a formal investigation, given, of course, that it's well known, again, in aviation and in transport, in railways, for instance, it's well known that the investigation of near misses, so in other words, accidents that did not happen, is just as effective in improving safety as the investigation and remedies following actual real accidents. So I think that near miss investigation needs to happen in AI as well. Of course, at the moment, there is more or less no investigation going on. The only AI accidents that have been investigated to date are those in driverless cars, where typically they are treated as of course, as serious car accidents, quite rightly. So there are all kinds of questions under that first bullet. What kind of regulation do we need? And what would it look like? And then the question is, do we need national investigatory bodies equivalent, for instance, to the NTSB, the National Transport Safety Board in the USA? Do we need, for instance, a national AI safety board? My view is that that would not be the best way of approaching this. I think it would be preferable to have specialist AI investigation bureau for each application domain. I think that the domains are so diverse that you need to have specialist bureau. And each one of those might, for instance, be managed by an existing domain regulator. So in the UK, we have the Health Safety Executive, the HSE, which is the body, the regulator that investigates workplace accidents. And I could imagine a specialist AI investigation bureau that would be managed by the HSE that would investigate all AI accidents falling within the purview of the HSE. But I think you would still need to have oversight and direction from a national body, and the recently formed AI Council, for instance, in the UK, which is essentially overseen by two government ministries, would be perhaps an appropriate place for that oversight and direction. But these are all questions, and as I say, I'm well outside my own comfort zone as an engineer in addressing these. So I'd be really very interested in what you might think of these questions. So that brings me to the end, and I just wanted to thank my colleagues in the Robotics team. Here is the URL for the Robotics project, and the references to the two papers that I mentioned in this talk. So thank you very much indeed for listening, and now looking forward very much to the Q&A. Thank you.
Okay. Okay, thank you, Alan, for that incredibly interesting talk. I mean, I thought there were a lot of important ideas, regulatory ideas that we might think about. I'm sure there are actually lots of questions, so perhaps our conference conveners could begin directing some of these questions to the panel members.
Okay, sure. Thank you, Professor Drahos. I do have some questions to the speaker. The first one is for Professor Pollicino, and the question is, to what extent the two different approaches, so the US and European one, are the result of the actual economic features of the two different markets and not of the two different legal frameworks? In the US, there are the most prominent word innovative operators, which are totally absent in the EU. So that would be the first question. And if you agree, I'll read the second one as well, which is directed to both Professor Stuurman and Professor Boesl, and it concerns the interests that are ultimately involved in self-regulation. So the question goes, while the public power has a responsibility with the societal good, industry is committed to their business model. The new factor in this equation is that nowadays sometimes they have similar powers. Would it be possible to make compliance with trustworthy AI a competitive advantage so that ethics by design would ultimately benefit the business model of tech industry, or is that too much of an utopia? So I would stop here and leave you the floor to answer this question, and then I have two other questions that I read after your answers. Thank you.
Shall I start?
Yes, please.
Thanks. So basically, the question is quite interesting, and in order to give an answer, I would like to let emerge it's a complex scenario that in a way let emerge the difference that I mentioned. The complex scenario is due to few aspects. The first one is the colleague that wrote is in a way very good, very well pointing out, is the economic market. And on the other hand, there is, as I tried to let emerge in my presentation, also I would say, constitutional matrix. Let me be a little bit more clear with the metaphor. I mentioned before the metaphor, that's one of the legendary, maybe even abused metaphor in constitutional law, the free markets of ideas. And this was a metaphor that, as every metaphor, has two domains, basically. The target domains and the source domain. Basically, the metaphor is taken from a domain that is the economic markets, free competition, and then it's lending the metaphors to the domain field that is the communication market. Now, why it's very dangerous to abuse, make an abuse use of metaphor? That should be handled carefully, exactly for the question that was raised before. Basically, this metaphor was in a way, first of all, used from, and I would say shift from the words of atoms to the words of bit. It was adopted and drafted in 1919, and for the first time, it was then translated in the words of bit by the Supreme Court in 95, the first time in which the Supreme Court of the United States had to deal with internet, saying that First Amendment, in particular internet, is the new free marketplace of ideas. So basically, what's happening here? It's happening that in a way, that idea of free market is shifting from the season and I would say the dimension in which it was drafted, that was a laissez-faire dimension in the first half of 900, to the internet structure. And until now, in a way, it's reasonable, because when the Supreme Court drafted these metaphors at the end of 90s, it was true that the internet market was in a way free. Then which is the unintended consequence of misuse of metaphors. That the same metaphors has been taken, has been borrowed by European regulators when they needed to fight disinformation. The European Commission saying basically why we should not use that metaphor in order to prove that self-regulation is the right answer to the problem, to the healing capacity of the markets. And this is the problem, because in the meantime, that kind, let's say, of source domain and the target domain changed totally the structure. More particularly, the target domain, this means the internet market and the markets of ideas, was totally different from the season in which it's been drafted the metaphors. In other words, it was not at all free, the market, but it was, as Brussels and DG competition during those years, was very, let's say, in a way characterized by oligopoly and by monopoly. This means that applying the original metaphors to a different context, there is not only the risk of reject, but there is the risk to basically try to regulate in a way a market, the market of ideas in Europe, that needs to be regulated in other ways. And this is the final answer. Which ways? The way that is more inclined, the way it's more conform, the way that is more, let's say, respecting the European constitutional DNA, that is basically, as I said, dignity, and especially a market in which freedom of expression is basically playing, it's playing at on the equal foot with other freedoms, with other rights, not like in the United States, where First Amendment is basically the, I would say, is really the cornerstone and is the roadmap for the rights. So this is very important, because the risk was basically to get a misuse of a metaphor and then leading to the consequence that we know very well. Which consequence? That the code of practice for disinformation, so the first attempt to regulate disinformation in Europe, was a failure. Why it was a failure? Because basically the idea was to apply that model in a context in which platforms needed an external source in order to comply with the requirement. This is my answer.
Peter, if that's okay, I'll jump into the second question. Francesca, I had some difficulties in grasping actually the second question. There seemed to be two parts. I hope Dominique understands the latter part. And the first part was about interest in self-regulation, the role of public power and industry. And if that's a good summary of the first part, then I'll continue. But be happy to please intervene if I have the wrong interpretation. Now, this issue of interest in self-regulation is obviously extremely important. If I focus again on standardization as an example of self-regulation in the prime example, as I explained in this field, and then it is very clear, but not that widely known as it should be actually, that there are standardization battles. The forefront of technological development is actually determined in the setting of standardization. So it's underestimated to what extent standardization decisions are actually shaping our technological future. And in those decisions, there are really major make or break decisions at stake also for companies. So navigating in the landscape from an industry perspective is very complex. And so there are definitely, everybody's bringing his own interest. We should not be too naive actually in embracing those kind of initiatives. However open and transparent they are, ultimately it's about interest. Interest from government, interest from industry, but also it should be interest from consumers' organization and workers' organizations. And I think that it's important that especially also the government is actively participating in that arena. There is some some tension, I would say, between the role of the government and standardization bodies also in Europe, but they are also intertwined. And as I explained, we have this standardization regulation, which is actually putting up a framework. We have some form of judicial oversight by the European Court, which is still to be developed in the James Elliott case, follow-up there. We have standardization mandates, or currently called requests, that are issued from the Commission to the standardization bodies, also creating some kind of legal relationship and obligations. And so it is a very complex relationship in which we should have a keen eye for the individual interest of both industry as well as government, but also look at it as a potential platform that can mediate between all these actors. And then there are procedural warranties, oversight warranties, that makes me think that this is a very powerful instrument. But again, we should be critical, and I refer to the remarks I made in that regard in my slide. So it's not Hosanna all the way, but it is an important instrument, and we can make significant progress by using it. That will be my answer. Thank you.
So yeah, maybe if I can add to that, I actually want to directly tie into your, it's not Hosanna everywhere. Perfectly right. What I also do see now to face the downsides of self-regulation, what shouldn't happen is what we're currently seeing is that corporate responsibility is something that is trendy with large companies and also chief executives. So I know from a lot of multinational companies that over the last 2 years, they all adopted some corporate responsibility agendas, and especially also in the field of now AI governance, technology governance, but it also goes into the field of green IT and all these things. The idea is very good, and especially the idea is good. And again, looking at green IT, this is, I think, a space where it worked quite well. Over time, there was public pressure. So you might know these charts from Greenpeace where they said, how green is your smartphone? And in the beginning, all the manufacturers were deeply in the reds. But then over time, it started that more and more buyers and more customers became aware of this and put pressure on the companies. And now it is something that those companies have to do. And well, I think last year or a year before, Apple even started an advertisement campaign in how much gold they obviously recycled from their phones. That said, we have to make sure that it is not just going to the field of marketing. You know, these corporate responsibility campaigns and also these whole efforts around self-regulation and governance, they shouldn't just be marketing campaigns. Matter of factly, it should be exactly the other way around. It should be more expensive for those companies to do marketing campaigns to hide their bad and dirty technology instead of driving good technology and not needing these marketing campaigns. And I think if we get to that amount of public pressure, that really, well, let's put it positively, that really motivates those companies to engage in driving good and responsible development of technology, also thinking about the impact of technology. And there are a lot of aspects to that, like cradle to cradle, upcycling, recycling, resource awareness, and then really also looking into the effects of their technologies. I think that is the right way to deal with it. The wrong way would be if we give them another means of marketing, just a marketing instrument, and that we make ourselves feel better, but in the end that there are no results. And we have already been speaking about the transition from soft regulation to hard regulation. Well, in the end, if we see that, or if the policymakers see that some of these governance initiatives are not leading anywhere, or that they're only leading to very weak measures, they can still try to convert those into hard regulations. So for example, like you need a corporate code of conduct. Now you need maybe an AI governance framework. You need a manifesto to that. You need to analyze the effects of the technology you're driving. And so gradually you can increase the pressure. Well, call me idealistic. Maybe I'm too young. Maybe I'm just too, well, happy sitting here in my basement over the last 2 years. But I still do believe that we can get to this intrinsic motivation, or to this half intrinsic and extrinsic motivation through public pressure. Worst case is we have to just use extrinsic pressure, and that would mean hard regulation. But yeah, in the beginning, I do believe that, and I also can perfectly agree to the point about that standardization is war. It to some extent is. It's all about interests, and I think governance frameworks will be the same thing. But as soon as they're commonly adopted, I think we're getting somewhere. And so yeah, this would be my answer to that question.
Could I, where is our conference convener? Could I perhaps jump in? I can no longer restrain myself, and I have to exercise, abuse rather my privilege as chair. And I have two sets of questions. The first one is directed to Alan. I thought it was a fascinating proposal. So one question I have for you, why does it have to be an either or? That is to say, why does it have to be a national body versus specialist bureaus? Because if we look at many areas of regulation, the best practice in a sense is to aggregate specialist knowledge. So one would want to look for ways in which committees working in different specialist areas would allow for cross-learning, because you said it was all about cross-learning. So that's my first question. My second question is, I thought your example of the aviation industry was fascinating, but it's also the most optimistic and best case scenario, because the critical point there is that the culture of secrecy does not exist in the way that it does in other manufacturing industries, and particularly where we see the rise on the reliance of trade secrecy at the expense, for example, of patents. And there are many debates here, I think, to be had about the desirability of this rise of secrecy, but it does exist in many manufacturing sectors, which would deeply problematize what you correctly recommend should be the correct culture. I have two questions relating, or I have a comment relating to the issue of standards. And standardization. I'm old enough to remember the Japanese effort to introduce high definition TV standards, which were blocked by both the United States and Europe. This occurred in the 1960s. We know that technical standards are often the object of many kinds of protectionist games. And we also know that these conversations now need to exist at a global level. And China, for example, is a player on the block in a way that was not true in the 1960s and the 1970s. And so, first of all, I think in order to have a meaningful dialogue, one would want to really take seriously how one can open up standard setting in a way that does not exclude all the key players, would be my first point. And my second point would be that this really has to be taken seriously, not just from a geopolitical point of view, but from a public trust point of view. We know that there is huge mistrust of experts, and standard development organisations are areas of intense concentration of technical expertise. And it is easy for these experts to lose the trust of the public. I mean, think just of the Codex Alimentarius and all the problems that we've had over the decades of standard setting in the food regulation area. And I can give you many other examples. So I think, you know, how are we going to move forward in a way that ensures that the public trusts this standard setting process? And I think we have quite a long way to go there. Sorry for my abuse, but I think these are very important issues that your wonderful presentations put squarely on the table.
So shall I go now and at least start to answer or address your question? Really good question.
Please, spontaneous ordering, Hayekian spontaneous ordering. Let's trust to that.
Perfect. Yes, thank you. So, I mean, my answer to the first question, why do we need, you know, either or? I really don't know. I mean, I have no I can't claim any special insights into this, and maybe we should have both. We should have both a national kind of AI investigation bureau and specialist teams under that. And as you say, Peter, quite rightly, that would best support, facilitate, enable the kind of learning, as it were, across the piece, across domains. As for the secrecy of AI technology, yes, AI companies, yes, you're quite right. And really, I think my answer to that question comes to an answer to Ben Wagner, who put in the chat window, how do we deal with manipulative AI actors who don't provide accurate data to the ethical black box? Well, I think this is where we need to go back to standards. So the point about the flight data recorder, for instance, in aircraft, is that it's a standard specification. In other words, the specification determines what data has to be stored in it very, very carefully. And the standard is supported by law. In other words, it would be illegal to fly an aircraft without that standard equipment fitted. So if we have the same for AI, then there would be a standard ethical black box defining precisely what data needs to be in it, and it would be illegal not to operate your AI without one, and therefore there would be sanctions under law for breaking that requirement. So now again, that's easier said than done, because of course what we've seen, and this is reflecting back on the previous question and the answers, that for instance that Dominik was reflecting on. The AI, big AI, it has shown itself to be breathtakingly irresponsible right now, breathtakingly irresponsible. And how do we get around that? Well, we have to have serious sanctions. And again, Peter, you reflected on old technology. Well, I'm going to reflect back even a little bit further than that. One of the reasons that Western manufacturing companies in the 1970s and 1980s had to embrace quality systems management was because of intense competition from Japan. So Japanese manufacturers demonstrated higher quality manufacturing of cars and all kinds of other things, and we were well behind, and we had to embrace total quality management. I think the problem is that AI right now is only embracing AI in as much as they can as marketing. It's kind of ethics washing. So it's a superficial veneer of ethical governance. And the reason that they're not embracing ethics throughout the entire organization, total ethics, as it were, is that there's no competition. The problem is that the big AI companies are all Silicon Valley companies, that we don't have the equivalent of large, competitive AI companies that already do quality well. So, in the absence of market forces driving ethics, I think we have to have regulation. There's no other way of doing it.
Do you mind if I throw something in there? Okay, so just to say, because before you just quickly said that, what can we do to ensure this? Well, I think what industry currently is terribly bad at, and what we have to do, and what we really have to enforce, worst case by hard regulation, is explainability and transparency of technology. And at some point, it's by design that they want to keep it secret. But at some other point, it's also just because we're absolutely lacking the capability of explaining complex technology in a way that the general public is able to understand. So that this is why usually press and media and marketing is rolling over it, because everything now is AI. We all here in this room know that a lot of that is not really AI. It's mostly statistical methodologies that have been around, or algorithms that have been around for 40, 50 years. So, but our job as technologists, be it in academia and especially in industry, should be that we have an interest in explaining technology so that people understand what it is about, that they know how to deal with it, and that they know what it means. And I think this is something that I would love to see put into either some kind of self-regulation, that this just becomes an ethical imperative that you say, if I build technology, I have to be able to explain it, or that somebody at least applies some pressure that this has to happen.
Peter, if you allow me to make a few remarks following your questions. You had actually two questions. First is on how opening up the standards setting arena for all key players. And there are various concerns, again, turning to my focus on the European small and medium-sized enterprises. For them, participating in the European standard setting process is difficult. It requires time. It requires actually sending off your best people that you need at home. And there are costs involved. Now, maybe one of the upsides of COVID is that everything has gone online, and that is one of the solutions that we also see in, for instance, IETF and others. It's not traveling around to expensive resorts around the world for standard setting, but it's online from within your company. So that's one thing. The other thing is on the power play on the global level, definitely standardization is also a WTO thing. We have a treaty on technical barriers to trade. So it's subject to this global set of rules on ensuring a level playing field. Now, as regards trust, I might be a bit less critical than you are. I still see in this time, also in COVID times, that there is a lot of concern about the public at large about expertise, but otherwise there are also a lot of reliance on experts. And if you look, for instance, in the Dutch situation, we can see that reputed institutes are still upright in this storm. Everybody's picking his own experts. But I don't think there is that kind of elaborate crisis that would actually put standardization under too much pressure. What is important is standardization is opening up. There are actually two main problems. It's a silo approach, all technologies that should open up to societal issues like responsibility, data protection, etc. So we need new people on board, and especially the internet can be the platform to take these groups on board in an easy way and lower the threshold for participation. So I don't see that problem as much. And I think actually that standardization have a lot of elements if it is opening up, if it becomes more flexible and maybe is slightly more transparent, then that is a great position to play an even more important role. So I'm confident that they will make it, but it requires a change of view and a change of style in some respects. We see some developments, but other organizations are less rapid in adopting. But I'm still optimistic that it is a very valuable platform.
Thank you. Thank you to all of you for those wonderful answers. So now I'll throw back to our conference convener, and perhaps she can guide us through the other questions that remain.
Thank you very much. Yes, there is one more question, which is actually directed to Professor Winfield. So the question is basically whether excluding or exempting AI producer or operators from liability could be, in your opinion, a solution or a useful way for improving cooperation between parties in accident investigation and hence the overall efficiency of accident investigation.
Thank you. Yeah, thank you, Francesca. Gosh, that's very hard for me. I'm not a lawyer, and I'm well outside my kind of comfort zone. I think probably yes, because the way that you kind of deal with this is that exemption from liability might well be permitted for specific accidents, for specific incidents. But of course, that doesn't exempt an organization for liability for kind of general, if you like, systematic failings across the piece. So, you know, I suppose an example of that would be, you know, Boeing and the 737 MAX. So, you know, Boeing was still, you know, sanctioned, if you like. I believe. Am I wrong? Am I correct about that? Were there any sanctions? I'm not sure at a company-wide level. So I think there could be sanctions at a company-wide level for failure to, you know, be transparent about the particular data recorded in the ethical black box, as I mentioned before. But that would still allow the relaxation, as it were, the point you've made about liability in the case of specific accidents, because I think there's such value in data sharing, and therefore the openness, the transparency. I don't mean the transparency of the detail, but the point is that the transparency in the community, in the industry, that results from that approach to accident investigation. I'm sorry, that's not a very good answer, but there we go.
No, indeed it was. Thank you very much. I don't see any other question in the Q&A chat, so I'll thank all of you. I'll thank Professor Drahos and all the other speakers for these they're very interesting presentation and for this very engaging discussion. We are running a bit late, so apologies for that, but we'll still take a 15 minutes break and then we'll resume with the presentation of the second paper from the EURA Young Scholar Prize. So stay tuned and we'll see you again in 15 minutes. Thank you.
Thank you.
Hello, everyone, and welcome back for this second part of the EURA conference. We are very happy now to have the presentation of the second paper that won the EURA Young Scholar Prize. And today we have Léonard van Rompaey, who is an industrial postdoctoral researcher at the Danish law firm Rompaey and at the Center for Private Governance of the University of Copenhagen Faculty of Law. Léonard won the prize with a co-authored paper on designing lawful machine behavior, roboticist legal concerns. So I do not want to take any more time from Léonard's presentation. So Léonard, the floor is yours.
Sorry, yeah. Thank you so much for this great opportunity to present our work here. Where all three of us, Robert and Catherine and I, are very grateful for this award. Yeah. So I'm an industrial postdoc researcher. That means I'm actually hosted by a law firm, but I conduct research in collaboration with the University of Copenhagen Faculty of Law Center for Private Governance. And the paper I'm about to present you is currently under review. Yeah, so the starting point was that essentially we felt like we were missing data on what producers, roboticists producing robots deem concerning and understand about their product and the law. We felt like we have data on what lawyer academics, engineering academics, and policymakers find concerning and relevant, but we were missing that data from the producers themselves. So that's what we went out, we were going after. We think this is relevant because to know what they understand of the law, of regulation, of their legal obligations, and what they find concerning with new applications of AI, complexity with Internet of Things, and so on, would be helpful in making better fitted regulation and to better target legal academic work. From my law firm's perspective, obviously, we want to know what are the kind of problems they are experiencing so that we can try and offer solutions. The conclusion from our research is that there definitely is a big set of difference between what lawyers understand of the law and deem concerning, and what engineers understand and deem concerning. Definitely the main outcomes, the main difference is that to them, legal concerns are a subset of safety concerns, which safety is itself in a nexus of wider concerns with functionality and economy, and safety is the least important one. They don't have a homogeneous understanding of the legal value of industrial standards, of CE marking. So that's the self-certification procedure producers have to do in order to put machinery on the European single market, and even of contractual content of disclaimers and so on. They tend to reject the possibility of unforeseeability or uncertainty in their products. They don't trust AI yet. And we definitely don't share common definitions of the technologies at stake. However, AI is still not a big part of contemporary, most advanced commercial robotics. So there's still a little bit of time to find solutions to the problems we're dealing with. So just a bit of background. So Denmark has a very big, I'm introducing Denmark because all our interviewers were from Danish robotics firms. So Denmark is a pretty big player at the European level for robotics, alongside Germany, the Netherlands, and Italy. And the things that we are, the type of technologies that they're developing and are in front of is collaborative robotics. So collaborative robotics, unlike industrial robotics, are meant to move around human beings. There you can see this is a mobile industrial robot platform with some kind of carrier on top of it. And it's designed in a way that it can interact and function around human beings. So some of the different technologies we interviewed, the pictures do not represent our interviewees, those are other technologies. Of course, I couldn't do that to keep our informants anonymous. But just a few examples of what other Danish companies have been building. This is the farm droid. It can sow seeds and also uproot pests. This is the UVD robot from Blue Ocean Robotics. Again, the mobile industrial robot platform there with a UV disinfection system, and you can parameter to work at night when no one's around in order to sanitize hospitals, airports, and so on. And this is a construction robot at work that's laying bricks. It can do a lot of other things. No, sorry. Something that's important to note about those people is, and their technology is the complexity and the modularity of their products. This, for example, the UVD robot or the previous mobile industrial robot I just showed, as you can see, it's a complex of different parts. Now, there's one producer that makes the platform, and then there's another producer that fits something on top of it, with everything also coming from sub-suppliers. So the kind of number of persons behind a single product can be pretty high. And also what is interesting is that, especially with, for example, that mobile industrial robot platform, it can't do anything on its own except move around. So it is built for modification. They intend for other producers to come and fit things on top of their robots to make them functional for the industry. And in terms of the chain of value behind a final integrated product, you essentially have, you have suppliers that will supply parts like sensors, hardware. You have then the producers like mobile industrial robots that builds the platform, and potential other ones that fit, for example, a UVD robot on top of it. But then the thing is that that's not the end of the value. The producers almost never sell directly to their clients. What happens is that you have a last actor in between that's called the integrators that have to adapt a specific robot to the specific industrial or healthcare or construction setting in order for it to be functional. So in terms of method, we did qualitative single interviews. We have 10 male chief technological officers or chief executive officers aged 40 to 60. Our interviews were about 45-60 minutes long, and everything was done digitally. Our interview guide comprised questions on safety, legal implications of safety failures, integration in the chain of value, machine directive, industrial standards, different AI methods, risks, unforeseeability, and ethics. This was a very hard process to get informants to accept to take part in our study. They were extremely wary of us as lawyers and practicing lawyers. We really had to play the academic affiliation that I have alongside some of our contacts in the engineering world in order for them to accept and trust us, because they really saw us as spelling trouble whenever we came towards them. So, in terms of analysis of what we have seen, as I was saying, the main outcome from this is that they understand legal concerns as a subset of safety concerns, which themselves are inferior to the function of their products, what it's able to do if it can pick up things the right way, and its economy, the price, and how much benefit they can make from it. So that's the order in which they see their different concerns. So as safety the function economy. For example, we have this quote there, the compromise is often I could make it safe, but no customer will buy it because it's too expensive. But then the thing is that safety is technical first and legal in second, as I was also hinting at. And for example, a quote that illustrates this is, safety is what we normally think of when we talk about legal issues. An accident that does not happen is an accident they won't have to be liable for. And then we found that they were very, very confident in what they call redundant safety mechanisms for their products. So they built in layers, they make their designs in layers where they have decision-making systems and sensor analysis parts, and then they have different layers of safety that can overturn control and make the system stop, for example, in order to keep it safe. The thing is that they were very confident that the safety measures they have built in their products would not necessarily stop a failure from happening, but it would definitely stop it from being a safety failure in the end. So having people hurt or having material damaged because of that failure. And a few quotes that illustrates this is, for example, every component will fail eventually if you have enough running. You need to take that into account, but our case was very simple because if something failed, then the system would just stop. And otherwise, you cannot go and say that you have unforeseeable failures. So failures they could not test for, they could not identify at the testing or the design phases, because that is very hard for the standard industry to accept. Because it is unforeseeable, then you cannot explain it. So that's a bit of a contradiction there, because in a sense, they say safety will never be a problem. However, we are aware that we absolutely cannot say there can be unforeseeable safety failures, which seems to me the most prevalent type of future safety failures we'll observe with enough running. And last important thing is that testing is the variable of adjustment. A few of the interviewees expressly stated that if they have to make a compromise on something, testing is their first go-to compromise. And the quote that expresses this is, so you have only a limited time to test because you are working 10 nights and finished, and you're testing maybe for 4 hours or 8 hours, but maybe I should have been testing for 3 weeks, but you don't have time to test enough, and that's the big issue. But still, even though they're aware of that lack of time of testing, they still go on and commercialize the product. I need to speed things up a bit. And also they didn't really give a legal weight. They didn't really recognize a legal weight to testing. They didn't think in terms of proof value, for instance. So another thing is compliance and how they understand their contractual relations. So as I was saying, we're faced with complex modular products. In the end, you may have a factory setting in the food industry that will compromise many different platforms with many different modules, and all of these come from different producers, themselves have many, many different sub-suppliers, and the technologies also interact, as was suggested earlier. Today, it's not just a question of AI itself or of robotics, but it's also its integration with neighboring technologies, cloud, IoT, and a lot of time, integrated systems in those factories have all those different technologies collaborating together in order for it all to work. So that makes for very long, complex chains of value, but let's see how they understand their relations to one another. So the main outcome from our interviews was that producers, like producers of, for example, it could have been the mobile industrial robot or the UVD robot, push responsibility to their integrators. And the reasoning is that as soon as integrators make some significant modification, it could be that they mount a different tool or something on there, they need to recertify. So perform again the CE marking I mentioned earlier. They need to do a CE marking again, because if you put a sharp tool on the end of course, safety changes as well compared to if we do not have such a tool on. For example, the way we can illustrate this is a universal robot arm. And as you can see there, it's just an arm. It doesn't have anything, any gripper at the end. Of course, the safety concerns change dramatically if you put a knife there or if you put a balloon. So that makes sense to a certain extent that they push some of the responsibility, but they were very adamant that as soon as you have the slightest modification, it's all the integrator's fault, none of ours. And I think that doesn't sit well with the fact that they are building products that are meant to be modified. They are not building definitive products. They are building products that are meant to be further modified, and they refuse to recognize that they have some level of responsibility for that ability for modification in the first place. And I think that that kind of mental state comes from the historical industrial setting for robots. So I think those are KUKA arms that are built in some factory setting. And as you can see there, I don't know if it's clear enough, but there's a fence around that robotic unit there. And as soon as you open a door here, everything shuts down. And I think that they're still a bit stuck in that kind of mentality of industrial setting. And that's why they consider that they're not responsible for modifications. Now, the thing is that they also have little fear for recourse actions. They are not concerned that the integrator might be condemned by a user for some kind of safety failure and damage, but they really weren't concerned about the integrator coming back, knocking at their door, saying, "You guys share some level of responsibility for that." And they were very confident in their contractual disclaimers. The disclaimer usually runs something like, as soon as this product is modified, we do not bear any kind of responsibility for it. But they gave a lot of power to those. They never considered that a judge might overturn those clauses. Also, they have a non-homogeneous understanding of industrial standards, of the legal value of industrial standards, which is a little bit more preoccupying. I'm just going to skip that. So what differences are left between lawyers and engineers then? And we've already have a bit of talk about this, about difference in definitions. And definitely one of the things that lawyers and roboticists don't agree on is what is a robot. And as it was mentioned, also roboticists don't agree on this, but at some point, we got into contact with a firm that develops software for bin picking. So bin picking is pretty much one of the hardest things to do currently in the automation world. Is that you have a box full of tiny parts and you need a robot to pick one and put it somewhere else, and that's actually extremely complicated. And when we interviewed some of those bin picking software producers, they said, at first, why do you want to interview us? We're not robotics producers, even though they were making the software that allows for this operation to happen in the real world. It also came back to questions of physical and digital robotics that also were pointed out earlier today. Is a digital robot a robot, or is it only physical? I think that my 2 cents on this question is that lawyers aren't necessarily wrong in saying that digital robots are robots as well. It's just that it seems to me like a lot of the legal concerns we have for physical and digital software are the same. And so to us, what matters is that the system has some kind of behavior and not necessarily that it has a physical embodiment. Now, some lawyers disagree with that, famously Kalo. So another thing is that AI in a robot does not make it AI. A lot of our informants had AI modules, for example, for vision or voice recognition in their products, but they refused to say our robot has AI. They did not agree with that statement. Our robot is not, it's not AI. It has AI, but it's not AI, which seems like it's also a different kind of perspective there, where we would tend to think that the robot is AI as soon as there's some kind of module in it. And to clarify, we're talking machine learning here when I say that they had AI in their products, not necessarily symbolist systems. But they definitely all want to implement AI in the future, that's for sure. I think that another very important thing that we observed is that they make a difference between perception and decision AI. when they did have those AI systems, I said, but how do you deal with the system making decisions? How do you deal with the, and we said, but no, it doesn't make, the AI part of it does not make any decision. It's just visual recognition. The system identifies grass as grass and feeds that to the decision-making part of the system, but it's not making any decision. They didn't think that maybe it does, in the sense that the decision system doesn't necessarily have a critical perspective on what another part of the system is feeding it. They were just going back to that stance, our redundant safety measures will deal with everything. And I think that in the end, that demonstrates that those producers didn't completely trust AI yet. And that's why they fell back on that position. So back to trust, AI ethics. That was replaced, trust in AI and ethics will always replace back in the safety nexus. It would have to be a customer demand. So our informants said, for example, we are not driven by the ethical questions, we are driven by customer demands. Or, are you concerned with trust, we asked. It's very important that the customer has a good feeling about my product, so they want to buy more. So here it shows real big disconnect by what we mean by trust and ethics and what they understand as trust and ethics. Maybe that's just that they are unaware of those conversations, that they feel unconcerned with trust and ethics yet, or simply that we're talking about things that are completely different. Great. So yeah, safety, more important than law. As I said, an accident that does not happen is one you don't have to be responsible for. Good enough tended to be the most prevalent standard, with some rare exceptions in terms of safety. And maybe an outcome of the study is that lawyers are a bit over-worried with safety failures and liability cases. That makes sense. We only ever hear of the cases where the machine breaks and hurts someone. Also, one outcome is that roboticists themselves wanted regulation and wanted harder versions of regulations. Yeah, so that's more or less it for me. I think that's also another thing, is that lawyers and policymakers could gain from adapting, we could gain from adapting our discourses to fit within that safety nexus in order to have a conversation with roboticists. Thank you.
Mm-hmm. Thank you very much, Léonard. I have already one question for you, which I'm reading right now. So basically, given the results of your investigation, where would you stand in the identification of the preferred solution between hard law and soft law regulation?
So one of the things we're working at with my law firm and the Center for Private Governance is how we can entice the good kind of self-regulation, the good kind of private regulation from the industry. I think that we need both. We can't possibly hope to only use soft regulation and self-regulation. Those are, of course, two different things. But my stance would be that we need a mix of both. And maybe one way to do it is by giving a stronger legal weight to questions of due diligence, of negligence, of trust, using the concept of good faith as an example. Because the way we assess diligence and so on, it seems to me that right now in our legal system, those are defined in a very negative way. And if we gave those questions of diligence a more positive meaning, in the sense that it's not just failing to do this, this, and that makes you negligent, but also being able to demonstrate diligence with positive steps, would be a pretty good incentive for more trustworthy private governance and self-regulation by the industry. So I definitely think that a mix of both is of both the soft, the hard, and the self is necessary.
Ci sono?
Sì.
Yeah. Oh, so I'm here, and so I have the little privilege of being able to speak out my question myself, rather than have it read by Francesca. So it's an interesting presentation. I saw that you were your analysis also, when I noticed it when I was reading the paper, kinds of converge with a study that we carried out some years ago for the European Commission, DG Connect, precisely on the role of system integrators in advanced industrial robotics. And given that we agree on that point, so the complexity of the duty to recertify whenever you adapt even a small actuator on the machine. And given the kind of analysis that you were making, I was wondering whether you would also agree on the fact that we should really seek simplification in the legal system, which is not so often the case. Meaning that when I say that, in particular in the field of liability, I mean that we should depart from considerations of blame. We heard it also from Alan before. We shouldn't so much focus on whom it is to blame, but rather who is best positioned to manage a given risk or associated with the use of the machine. As you said, at times lawyers overemphasize the issue of liability, but the issue of liability is also related to investments, is also related to research. So it's not just, I'm not so much focused on liability as a tool to blame somebody that did something wrong. And this is precisely the reason why I am in favor of what I like to call a risk management approach. So I was wondering, what do you think about seeking simplification by radically avoiding the issue of seeking someone to blame, and therefore adopting systems that are much more simplistic to some extent and place a liability burden, for instance, on a party that is best positioned to minimize that risk? And that could be, in some cases, the system integrator. In other cases, it could be the industrial player that is using the technology, or in some cases the manufacturer, but the manufacturer is always problematic, and I'm not a big fan of the Product Liability Directive as it is today. Thank you.
Yes, thank you very much for your, hear myself in echo, no, that's better. Thank you very much for your comments and question. So one of the things that we've observed is that integrators are famously poor. They're definitely the most busy people in that chain of value, and they're definitely the ones that make the least money. So just for purely practical reasons, focusing too much on their responsibilities might lead to people not getting compensated just because those businesses don't have the funds to compensate in the first place. I'm not sure I could be able to meaningfully contribute on the question of simplifying the legal system. I would definitely rather ask this to my co-author, Robert Jonsson. I think he would be better able to answer that question. However, I would tend to think that it's definitely a good idea to have this risk approach, because in the purely blame perspective now, we try to find who's been negligent and who hasn't respected the state of the art, and who has failed its due diligence and safety measures. And I get the impression that with the further integration of advanced AI techniques into robotics, whether digital or physical, we are observing a change in the nature of risk, where risks are becoming more and more unforeseeable. I wouldn't be surprised in the future if the massive deployment of robotics led to a drastic reduction in accidents. But the accidents that would happen, I think, will tend to happen more for unforeseeable reasons than they have been until now. And the problem with that question of unforeseeability is that in some legal systems, for example, in the US, this question of foreseeability is necessary to attribute responsibility in the first place for product defects. It's a bit different in the EU system, and I'm sure you are more expert at this than I and Leah. But we still have that question of defectiveness that somehow gets close to that concept of unforeseeability in the US system, which leads me to answer. I'm concerned that producers would be responsible from a causal perspective because they have set up the system, they have done or not the testing. But because the safety failures that will happen will be unforeseeable, they won't be responsible or not as much as they maybe should have been. So going to that risk management aspect, we displace the risk on who is able to prevent it from occurring. It might also profit from changing the way we understand risk in the first place, because the way that I understand risk to be understood at the moment, at least in the judicial system, it's a very specific risk that is taken. If we don't necessarily take into account the general and more broad types of risks that the system generates in its functioning, we specifically look at what is the specific risk of that item breaking down or that system malfunctioning that has led to that specific outcome. And because of unforeseeability, I think that won't work as well. But yeah, I'm not sure I'm answering your question though.
You definitely have, Léonard. Thank you very much. I do not see right now any other question, but maybe if you want to show again the slide with your contact, just in case someone from the audience maybe wants to contact you privately or with follow-up questions. And in the meantime, I'll just thank you again for your presentation and for the discussion. Congratulations again to you and your co-author for winning the EURA Young Scholar Prize. And with that, I will thank the attendees as well. And we will have our lunch break now, and we will resume again at 2:15, so 2:15, for the third panel on when to regulate. Thank you very much, and we'll see you again shortly.